Mr. Attorney General, there has been a discussion, a theme in some parts of the hearing which have raised questions about the balance between security and the guaranteeing of rights as meted out under various situations, military courts and Article III courts. I would simply note that that if this is about rights, it is also about responsibilities, and both are constitutionally based. And to the extent that the authority that is vested with the power to implement policy in the country pursuant to constitutional principles are true to those constitutional principles, then we are a better nation. To the extent that we don't do that as well as we could, or try to do it as well as we should, then we need to step back and regroup and address the shortcomings and then move forward. I really commend the administration, I think, for doing that, and doing it in a way that is very sensitive to the national security concerns that were obviously paramount in the last administration. I think that's to your credit. I also think it's to your credit that in stepping back, you have embraced process in order to assure that our faithful fulfillment of our responsibilities in adherence to constitutional principles are assured. And I think you certainly have done that in the review of the detainees at Guantanamo. I think that's commendable, the defining distinction between the way these detainees were initially handled and the way that this administration has handled them has to do with process and bringing criteria to the table and really being sensitive to that. And that's, frankly, it's a statement not to be insensitive to the national security concerns that the last administration was faced and preoccupied with. It is to your credit that that in pursuing those same national security goals that you backed up and did it with a sensitivity, I think a greater sensitivity to those rights that are constitutionally based and which really defines us as a nation, recognizing that you also have responsibilities, and you're the power, and so you're exercising those responsibilities, achieving national security purposes, and at the same time being sensitive to the principles that define us as a nation. There are a lot of issues that were raised, but I would like to address two quickly by Mr. Culverson, principally, that were raised by him. The Galani case. With respect to that case, can you elaborate on the statutory and other protections that will guide you with regard to what information and how much information is shared and how that information will be safeguarded in the course of that proceeding?
If the prosecutors in that case make the determination in consultation with the intelligence community that information should not be shared, should not get out of the confines of the courtroom, there are mechanisms in place, principally the CIPA statute, CIPA statute, that allow for that to occur. And that is something that is fairly routine in terrorism cases where a motion is made, judge looks at the motion. There are lawyers from the other side who have gone through the security clearance process, and the information is contained within the courtroom. we have judges, particularly in New York and other places where these cases have been tried, who are familiar with the very legitimate concerns that Mr. Culberson raised, but who handle those concerns, I think, in an appropriate way, using the tools that Congress has given them, and chiefly the SEPA statute.
Now, there were some fairly complicated constitutional issues alluded to and questions asked that I think were inviting serious answers, which, seriously proffered, should be seriously listened to. The one issue that I think I would like to hear you speak to, with time to do it, is this comparison with the two cases of the murderer and Manson, who obviously was a murderer. To clarify what your point was, which I think it's important for you to characterize your point rather than your point to be characterized. So I'd like to give you an opportunity to characterize and to elaborate on the point you were making.
Yeah, I mean, the point I was making was that I frequently hear the notion that these terrorists are getting rights that the average American would not get. And I think that runs headlong into the fact that, to the extent that we decide to bring terrorists charged with criminal acts into the criminal justice system, they're not treated as average Americans. They are treated as murderers. They're treated in the way that their crimes would have them be treated. I used the Charles Manson example only because I was thinking of a mass murderer, and thinking that with regard to some of the people who might be brought into the Article III courts, they also would be mass murderers. And so they would get, I'm not sure you use the word protections. I don't think that necessarily conveys what I'm trying to say. They would be treated in, the same way, which doesn't mean that they're going to be coddled, which doesn't mean that they're going to get treated with kid gloves. They would be imprisoned before trial. They would be in holding cells that are, if you look at the detention facility in New York, these cells are extremely small, they're drafty, they're not pleasant. It is not for these people who are brought into the Article III system and who are charged with these serious offenses. It is not at all a pleasant experience. And that's what I was trying to convey. The comparison is not between the average American and these terrorists. The comparison is between those people who have committed the most heinous acts and who are charged in our Article III courts. That's the comparison that I think is more apt. Again, what I've consistently said is that not everybody who we determine should be tried will be brought into Article III courts. Some will be tried in military commissions. I've already made that determination. The comparison I'm making is only those in Article III courts as opposed to other criminals brought in Article III courts.
And I know that was extrapolated, if you will, to the mastermind or the policy head of one of the most heinous crimes committed against on the domestic shores of the country. And I just felt it'd be useful for you to note that that was not your comparison or your analogy, and that the facts that would evolve there would be totally around the circumstance. I know the law is very good about looking at the case and deciding things on a case-by-case basis and understanding how constitutional principles are applied, which are, in fact, constitutional principles. And again, the measure of one measure of the country is to the extent to which it honors those principles to which we affirm.